Executive Director of the
Committee on Open Government. Thank you.
And he's the expert on open government.
Yeah, you'll make your own judgment, but thank you. Yeah, how many of you are familiar with our office? Quite a few. I'm shocked. Some of you are not. It's a unit within the Department of State, very small. The staff is 3 of us at full strength. I describe it as the smallest state agency that actually does anything, and leave the rest to your imagination. Yes, and I've had forever, and we may get into that later too, the best job in state government. It's fairly simple. All we do all day, every day, is offer advice, opinions, guidance, training to anybody who wants to know about public access to government information in New York, primarily in relation to 2 laws, our Freedom of Information Law, many of you know it as FOIL, and the Open Meetings Law. And when I suggest to you that we give advice to anybody, I mean exactly that. We take loads of calls from local government officials, more from local government than any other group. We hear from state agencies, members of the public, members of the news media. It doesn't matter. Our only goal is to give what we believe to be the right answer under the law, regardless of the source of the question. So we're not there to support the government necessarily. We are there to do the right thing. Some people believe that those two are mutually exclusive. I hope not. How many of you are familiar with our website? A few less. We have an immense amount of material that's available at your fingertips. If you are taking notes or you want to have a great memory, just Google COOG for Committee on Open Government or FOIL. You'll get there. And on our website, we have, again, a tremendous amount of material. If you scroll, for example, to Open Meetings Law, you'll see a series of drop-down boxes. One will say text of the law, easy. A second one will say frequently asked questions. And generally speaking, when you do have questions, you go through that. Your questions will be answered in most instances. Most importantly for so many people, the third box says advisory opinions. This will sound crazy. We've written over the years about 25,000 advisory opinions. They are indexed by key phrase. One of them deals with FOIL, the other the Open Meetings Law. And I'm not going to mislead. The opinions are just that. You read an opinion, you don't like it, you can say, throw it away, say Freeman just doesn't know what the hell he's talking about. That is your choice. The hope, of course, is that the opinions are educational, persuasive, that they encourage knowledge of and compliance with law. And for what it's worth, where the courts have reviewed our opinions, they've agreed in the great majority of circumstances. So, again, if it's 4 in the morning and you have a question that you're obsessed and you need an answer, don't call. Go to the website. You'll probably find the answer that you need. Certainly, anybody can call anytime. We always return the calls. If I am not there, our assistant director, Kristen O'Neill, is also an attorney. She knows the law code. She'll be able to help you as well. Now, I am here for you. I am completely unprepared. I can talk about this stuff from now until doomsday, if you let me. But if you do, we'll miss the issues that are really important and troubling to you. So after one more minimal suggestion, I throw this open to you. What I want to leave you with tonight is the general notion that the 2 laws that we're talking about are based primarily on reasonableness and common sense. Common sense. All they really say, all they should ever say, in my opinion, is that everything is open except to the extent that disclosure would hurt significantly either somebody in terms of an invasion of privacy, the government in terms of its ability to do its job well on behalf of the public, or sometimes a private company in relation to its competition. So the real question in so many instances is pretty simple. What would happen if the government had to disclose? And unless the answer in the gut is, ouch, this would really hurt, chances are pretty good that disclosure should be the outcome. Now, obviously, that's an oversimplification. We have too many laws in New York. They're not necessarily consistent. But that is the general thrust of our open government laws in New York. So, what's your preference, FOIL or the Open Meetings Law?
No.
Do you have a preference?
Open meeting.
Open meetings. Are you a board member?
No.
No? Why open meetings? I'm curious.
I'd like to go to them,
You can.
I mean,
Do you?
some.
Some. Okay, Open Meetings Law. We look at the Open Meetings Law, and it applies. Member of the news media?
Yes, I
No
am.
kidding. Yeah, you know, for the most part, the teenagers in the room, I know are reporters. I mean, it's simply the way it is these days, you know? Do you get paid a lot of money? No, do you get paid a lot of money?
Negative.
No. Yeah. Of course, I work for the state and have for many, many years. Do I get paid a lot of money? Not a hell of a lot, no. Anyway, the open meetings law applies to so-called public bodies. A public body is an entity consisting of 2 or more members, usually either elected or appointed pursuant to law, to carry out some sort of governmental function collectively as a body. Town board, probably 5 members, clearly a public body covered by the open meetings law, city council, zoning board, board of education. The kinds of entities that I just described are all public bodies covered by the open meetings law. The question that arose on day 1 of that law, 1977, was pretty simple. What is a meeting? What is a meeting? And all over the state, various boards, committees, councils were saying, well, gee, we're just going to get together to talk. We're not going to take any action. This isn't a meeting. It's a workshop. It's a work session. It's a study session. It's everything but a meeting. Well, we disagreed, as did the state's highest court, and since the late 70s, it has been clear that any gathering of a quorum, a majority of the total membership, for the purpose of conducting public business, is a meeting covered by the open meetings law, even if there's no intent to take action, regardless of what it's called. Now, let me ask, is there any public body here that has a majority of members here in the crowd? You have 3 town board members? No? City council members? No? Well, let's say just for the heck of it that there were 3. 3 out of 5, that's a majority. If there were 3 out of 5 here, would you be in violation of the open meetings law? No. No, because the 3 out of the 5 would not have gotten together for the purpose of conducting town board business collectively as a body. They would simply be 3 people within a larger audience. Nobody would walk in and say, looks like, smells like, tastes like a meeting of the town board, because it wouldn't be. Okay? Questions about that? Yes?
If a body, a town board body, makes a special committee, say for economic development, and they make it 2 members from the board, 2 members from the public, and they only want to conduct their communications by telephone, is that meeting or not a meeting?
They're not covered by the open meetings law, because I'm assuming it's an advisory body.
Yes.
It does not consist solely of members of the governing body, the town board. Judicial decisions going back years would indicate that it is not a public body covered by the open meetings law. That means they could do whatever the hell they want. Now, let's ask the question differently. What if members of the town board, 3 out of the 5, wanted to conduct business by phone, or vote by phone, one by one by one by one? The answer in that situation would be different. It would be different. Why? Because the open meetings law does not permit a board to conduct a valid meeting or take action except at a meeting held in accordance with the open meetings law, which would mean either a physical coming together of a majority, or now a virtual coming together by means of video conferencing. It doesn't happen that. You looked at me strangely.
No.
Yeah, you did.
No.
I saw why. Is that news to you?
Well, I go to the town board meetings,
Yep.
and 2 people go to Florida for
Go
the,
figure.
and so they could go to a town hall in Florida
Or
as
sit in
a,
their condo.
so being
Or
that
the
it's
hotel.
videoed, it would be,
Because they wrote themselves out of foil, didn't they?
Not exactly.
What did they do with
Do
foil?
you want to know about that?
I do, that's why I asked.
Okay. You didn't ask, you just made a comment.
Well, I have more comments.
We read all the time, the governor keeps saying, the legislature's not covered by FOIL. It's not true. The legislature is covered by FOIL, but differently than the rest of government. As FOIL applies to county, city, town, village, school district, state agency, public authority, basically it says that all records are available with certain exceptions. As the law pertains to the state legislature, instead of saying everything is available except, It says that the following categories of records are available, in essence, to the exclusion of everything else. Now, to be honest, my belief is that in most cases, when the average person wants to get a record from the state legislature, more often than not, it's included within that list of available records. You know, some people like to make an issue out of that for who knows what, political reasons, you know, to sound like a whatever. To sound as though he or she is the most transparent person who ever lived, and, you know, those who say it the most are usually the least. Did I say that? I did. I did.
Out
didn't
loud.
I did. I did. Does that answer your question?
It did, thank you.
Okay. Yes. Yeah, you.
Okay. In our county government, there's a huge room, and the supervisors sit far away from each other, from one end of the room to the other, without the microphones on. Do we have any right to ask them to put, when they have a very soft voice?
Of course you do.
Okay.
Didn't I just refer to the statement of intent? The public has the right to attend, to listen, and to observe the performance of public officials. And certainly, if you can't hear them, you say to them, we have the right to be able to hear you. Please situate yourselves in a way in which we do have a reasonable capacity to do so. And I'll make a suggestion. You go to our website, to that advisory opinion listing, and you click onto H, and you scroll down to hear, comma, ability to.
Okay.
And we have opinions that deal with that very issue, You know what they do, if they're doing that and they're speaking softly, they are disrespecting you. They are disrespecting you. And the more they disrespect, the more you vote the rascals out. That's the way
But
I
you're
see
not
it.
allowed to talk when you're in there.
Oh, but you assert yourself. Yes, you do. Yes, you do. You bring
I
up
do
an-
my best.
You bring up an interesting point. The open meetings law, as I said a moment ago, gives the public the right to be there. It says nothing at all about the public's right to speak. If a board does not want to let the public speak at all, that is its choice. Now, most boards do permit some sort of limited public participation. If they do, the suggestion is that they establish reasonable rules that treat
Right.
members of the public equally, so that they can't say, we like you, we'll let you speak for 3 minutes, but the guy next to you is a pain in the neck, we'll let him speak for 1 or not at all. Yeah. Does it give you the right to speak? No. But it does give you, in my opinion, the right to engage in minimal civil disobedience. We can't hear you. What the hell's wrong with that? Nothing. Nothing. Yes.
Okay, you've done
Okay.
many advisories for me
I
on
have. Who
committee
are you?
meetings. Joanne from Schoharie.
Hello, Joanne. From
So
where?
I have one
From
for
where?
you,
From where?
Schoharie.
You came a long way.
I did, just
Why?
for these.
Why?
Because we keep catching them going in illegal executive sessions, and
Yeah.
they keep finding ways around it, and then they just go back to the way they started.
Yeah.
So this is off of our personnel.
Do I need this? Do I need this?
Yes, because this is your personnel committee minutes. These are some backfills they were filling. And then they go to an executive session to discuss personnel issues.
Woo. Have you ever heard that before?
Oh,
Should we
yeah.
Go into executive session to discuss personnel?
Yes.
I want to suggest what I've come to call the personnel myth to you.
Read what they do.
I don't care what they do, I'll tell you.
You
I'll tell
don't
you.
even give a reason.
What is the personnel myth? How many times have you heard on TV, the radio, read the newspaper, it's personnel matters, confidential, can't talk? Have you ever heard that? There's no law that says that. There is no law that says that. But, you know, we in this country in too many instances have become stupid and sheep-like. We hear these things over and over and over again. We begin to believe them. That's when we begin to lose our rights. The word, you look at, there are 8 grounds for entry into an executive session. The word personnel doesn't appear anywhere in those 8 grounds. How about personnel records? You look at FOIL, the word personnel is nowhere to be found. And yet we hear the word all the time. I will suggest that it be eliminated from people's vocabularies. It is a trap, it is garbage, it is crap. That, by the way, is a technical legal term. Anyway, just to put this in perspective, I hope that everybody knows that an executive session is defined by the law to mean a portion of an open meeting during which the public may be excluded. So an executive session is not separate from a meeting, It's a part of a meeting. Am I driving you crazy, by the way, by moving around?
No, not at all.
Second, to go into an executive session, a simple procedure has to be accomplished in public. It involves 3 elements. Number 1, somebody on the board or council or commission or whatever it is has to introduce the motion in public. Number 2, the motion has to indicate what they want to talk about. And number 3, the motion, again, has to be carried by a majority vote of the total membership. From there, we look at the 8 grounds for entry into executive session, and we ask, where does this fit? Does it fit? Does it fit? And in fact, I'll make a suggestion to you and everybody else here. If there are questions about a board's ability to go into an executive session, have your copy of the open meetings law with you, so you can get up and say, wait a minute, board, here are the 8 grounds, please tell me where this fits. Now, in terms of the so-called personnel-related issue, personnel can mean 1,000 things. Could it mean, anybody here from a school board? Anybody here, yes, no, maybe, kids?
Yeah.
Teacher.
Yeah, teacher. So, it's school board budget season, isn't it? Yeah. So what if the board says to itself, gee, things are kind of tight this year. Should we keep or get rid of that position of our teacher in the elementary school? What if it's a small school district? There's one elementary school, one art teacher, everybody's going to know who it is. No basis for closing the doors. Why? Because the issue involves policy. How do we as the board choose to allocate public money, number 1? Number 2, is art really important to the education of our kids? Yes, clearly it's a personnel matter, but there would be no basis for conducting an executive session. What if, on the other hand, the question is, does that teacher deserve to be retained or canned? That's different. Why? Because the issue, in the words of the law, focuses on a particular person. A particular person. And the language of the exception is precise. It says, and I'll quote, it says that a board may enter into an executive session, not must, but may, to discuss, quote, the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. So to qualify, the issue has to focus on somebody or some specific corporate entity in conjunction with one or more of those modifiers. So a proper motion might be something like, I move to enter into executive session to discuss the employment history of a particular person, or something like that. Wouldn't have to name the individual, but if you tell the world that much, what you're really saying is, yep, we've read the open meetings law, and unless we're fibbing, we are about to conduct an executive session for a valid reason. Okay? Yes, sir?
Well, in your example, it's protecting the person being discussed from some harm?
Either that, or it's giving the board the ability to speak freely with respect to something that may be somewhat intimate or personal or something like that.
But if it is to protect me from harm,
No, not necessarily. Maybe, maybe not. Maybe, maybe not.
well, if it were,
Yeah?
could I waive that?
Could you waive it?
Could I say,
You could try, but
you're gonna discuss
What you
me?
say doesn't matter. It's the board's determination. If the board has a basis for going into an executive session and you say, I don't care, I want you to discuss it in public, you're gonna be talking about me, it doesn't matter. If they want to, they can, but they don't have to. They don't have to listen to you.
Right.
They may, but they need not.
But what if they keep doing that? Like you send an advisory and it says they were wrong, you didn't do it. Next month, they change to a caucus for a little while.
What's a caucus?
A caucus would be 14 out of the 16 supervisors being Republicans who say, we just want a caucus right now.
Shh. They can do that.
Right,
Stinks.
if they
It
can.
stinks. Should we talk about that for a moment?
Yes.
They can.
The political caucus, among the worst provisions of law ever enacted, history. There is a second vehicle, a vehicle other than the executive session, that might permit a board to close the doors. And that vehicle involves what are characterized in the law as exemptions. They appear at the end of the law, section 108, and If an exemption applies, the open meetings law does not. It's just as though the open meetings law doesn't exist. One of the exemptions since day one has involved political caucuses. Well, right from the start, the question was, gee, what is a political caucus? We offered opinions. 5 courts agreed with us. And the primary decision came out of the appellate division, City of Rochester, 9 members, 8 Democrats, 1 Republican. The 8 Democrats would routinely get together before their regularly scheduled meetings in a closed caucus and discuss what they were later going to discuss during the open meeting. So, the caucuses were 2 hours, the open meetings were 10 minutes. And, you know, the 9th member, the Gannett newspaper, got peeved and they sued and they won. And the court agreed with us. And the notion was, if a majority gets together to discuss public business, it's not really a political caucus, it's really a meeting covered by the open meetings law. Only if the issue involves political party business would the caucus exemption apply. That was the law until 1985. When a reporter from the New York Post, as I understand the situation, wrote to the Speaker of the Assembly, which then as now had a significant majority from one party, and said pretty much, unless you open your caucuses within 2 weeks, we're going to sue you. Well, instead of being sued, the state legislature acted in uncharacteristic fashion and changed the law within 2 weeks. And what has it said since then? It has said that the members of a particular political party who serve in the state senate or the assembly or the legislative body of a county, city, town, or village can meet in private in a closed political caucus to discuss anything, including matters of public business. So, if your board is 14 to 2, the 14 can meet in private, call it a political caucus. It's legal. Does it not stink? It does. It does. It does. I think it's the stuff of editorials and voting the rascals out, but it's hard to do that. Now, are any of you associated with bodies that consist entirely of Republicans or Democrats? Yeah?
My town board,
Your town board?
which
Well,
is also all the members of our fire department's rule.
fire department doesn't count because it cannot hold a closed political caucus, but the town board could, but not in this instance. Why? I'll tell you the background. You know, the state legislature, as part of its rationale, said, you know, we're bicameral. You know, if we, the Democrats or the Republicans, have to discuss public business in public, we'll be telegraphing our political party strategy to the other side. We don't want to do that. Well, in the city of Buffalo, several years ago, the city council, all Democrats, wanted to go into a closed caucus to discuss the budget. Well, the Buffalo News brought a lawsuit, and it won. And the court said, all members, all 15 are Democrats, there's nobody to telegraph your party strategy to. Therefore, if a board has a unanimity of membership of one political party, and it's discussing public business, it cannot claim the exemption involving political caucuses, only if it is discussing purely political party business. What do we do about fundraising? Who are we going to run in the 14th district? Yeah, in that situation where it's purely political party business, it could conduct a closed caucus, but otherwise it cannot, at least not if it's going to comply with law. Yeah?
What if you had something like, say, Southern Poverty Law Organization?
Yeah?
They muscle themselves politically of saying they've got so many votes of saying this or whatever. Do they have any authority to interject? I mean, we see them being manipulated with, like, say, NRA or whatever.
Who's not manipulated, for goodness sake? You know, it's not a governmental entity. They could do whatever they want. They could say whatever they want. Right? Southern Poverty Leadership, so can the NRA, so can the League of Women Voters, so can the Girl Scouts of America, so can the Little League. You know, they're not government. They're not government. Yeah?
I want to just switch gears to FOIL for a moment. What do you consider to be a reasonable number of FOIL requests in one request for information?
Impossible to answer.
If you saw a request for 68 items, would you consider that reasonable?
Can they be found
Yes.
with reasonable effort?
Yes.
Then it's a valid request.
What if that was 160?
Same answer.
What if it was 200?
Same.
1,000?
Maybe. This is a question that comes up on occasion. The question involves the size of a request. The request involves 68 items, or 168, or 568, or 1,000,000. FOIL doesn't speak to the volume of a request, but it does address, let us say, related issues. I asked whether the records could be found easily. Why? There are so many instances when somebody says, you know, I knew the record was there somewhere. It's in the basement someplace. I went through a dozen boxes. I found 2 pages. What can I charge? And the answer is nothing if someone so wants to inspect, 25 cents per photocopy. If they want a photocopy, but you exceeded your responsibilities under FOIL. Why? Because FOIL says that an applicant must reasonably describe the records requested. And the Court of Appeals, the state's highest court, has said a couple of things. Number one, yes, agency, if you have the ability to locate and identify whatever it may be with reasonable effort, yes, the request reasonably describes. And the key case involved a really bad guy. He'd been in jail for a long time then. The case was started in 1986, and he just got out of jail recently. He essentially wrote to the Department of Correctional Services and said, I want whatever you can find based upon my name or my ID number. And they said, what do you want? He said, I want it all. They were able to locate and pull out 2,300 pages of material. And they asked him again, what do you want? He said, I want all of it. They said, sorry, you haven't reasonably described the records. Sue us. Well, they didn't know that he had, let us say, unusually well-heeled associates, yes. And he went all the way to the state's highest court, and the Court of Appeals said, Department, you were able to locate these 2,300 pages of material based upon the terms of so-and-so's request, therefore, he met the responsibility of reasonably describing the records. Now it's your job to go through the stuff to figure out what's public and what's not. But the court also said that whether or the extent to which a request reasonably describes the records often is dependent upon the nature of an agency's filing or record-keeping or retrieval system. Let me give you my silly, stupid example. What county do you live in?
Madison.
Madison County. You've come a long way too, haven't you? Huh. I walk into City Hall in Canastota, or Village Hall, whatever it is, and I see the Madison County phone directory. And I ask myself, what's your last name?
Porter.
Porter, I hereby request all the listings in the phone book pertaining to those people whose last name is Porter. Piece of cake, right? That's how the phone book is written. Last name, alphabetical order. Even if there are 10,000 people with the same last name, the request would reasonably describe. What's your first name?
William.
William, not an unusual name. I come in the next day and say, you know, I like the Porter part. Now I want all the listings pertaining to those people whose first name is William. Huh, the request is specific. You know that there are Williams there, but you can't find them unless you go through thousands of listings one by one. That's when the agency can say to you, sorry, we maintain this group of records by last name in alphabetical order, not by first name. We know that there are Williams there, but we're not required to go through the haystack in an effort to find the needles. Again, even though we know that there are needles there somewhere. But let us say, just for the sake of the discussion, that the same data, if you will, is maintained electronically. Somebody can sit at the keyboard, enter a query, all the Williams come up on the screen. The law says that when we have the ability to extract or generate or retrieve data maintained electronically with reasonable effort, yes, we are required to do so to comply with FOIL. Okay? That was part one of the response. Part two. If an agency wants to jump in response to a request, yes, it may choose to do so. But it doesn't have to. It doesn't have to. If the agency needs more than 5 business days to deal with a request, it must acknowledge the receipt of the request in writing. And if it needs more than 20 additional business days, it is required to give a reason, and it is required to give what the law refers to as a date certain, a self-imposed deadline. Yes, we promise, we swear, we will make the records that you've requested available in whole or in part by such and such a date. As long as that date is reasonable, the agency is complying with law. Okay? Does that help you?
Yes, but what if they say we'll give you in whole or in part, number of documents, and they give you just a fraction of what they should give you and say, all of this is, it contains personal information.
Stop. In any situation in which any aspect of a request is denied, they have to tell you that you have the right to appeal. And the appeal goes to the head or governing body of the agency. It has 10 business days to do one of two things: make the records available or fully explain in writing the reasons for further denial. Continuing, let's say that they say, no, you can't have it, and you think that they have no reason, no valid basis. Under FOIL, and the law was amended just a couple of months ago, just
I was gonna ask you about this, I'm so sorry.
restrain yourself, will you? Do people know this lady?
No, just now.
No, she's not from this county.
We're all in the same boat.
We're all in the same boat. Okay. Is it a sinking ship or what?
Don't
It's
have
sunk. Anyway, now, well, hello. First of all, many of you missed the best part.
I was at a bar association meeting.
Oh, I thought you was gonna say she was at the bar.
We held the meeting at a bar.
Generally speaking, when somebody challenges a government agency in this state, it's the Article 78 proceeding. Article 78 of the Civil Practice Law and Rules, and you, John or Jane Q. Public, have the burden of proof. You have to demonstrate that the government acted unreasonably, or something like that. Tough burden to meet in many instances. Under FOIL, the burden of proof is reversed. The government agency has the burden of defending secrecy, and the Court of Appeals has said, in a variety of contexts, FOIL is to be construed expansively to promote broad rights of access, number one. And number two, an agency, a government agency, can't simply say, well, disclosure would invade somebody's privacy. The phrase in the law is unwarranted invasion of personal privacy, and the courts have said you have to demonstrate how and why that effective disclosure would indeed arise. You can't just say no. You can't just say no. Now today, should you go to court under FOIL, and if the court finds that the agency had no reasonable basis for withholding, the law says now, were you at the Bar Association too? Yes. Yeah, you were. Okay.
Well, I got here before her, so I want credit.
So many, you ran a red light. Yeah. Anyway, if you go to court and the court finds that the agency had no reasonable basis for withholding, the court now must award you attorney's fees payable by the government. It's mandatory. It's mandatory, and the hope is that this will encourage compliance. The goal is not to sting the government. The goal is to encourage compliance. In your situation, let's say that the agency drags its feet and you bring a lawsuit and you substantially prevail, but it's not completely clear-cut. You substantially prevail. In that situation, the court has the authority to award attorney's fees. It's not mandatory. It is discretionary on the part of the court. Yeah.
Sir, I don't know if you remember me. You helped me when I was a police chief here for about 20 years. I called you during a sunshine week, probably 6-8 years ago.
I remember the call. No.
But you may, because I was trying to comply, and the newspapers would not tell me. I was trying to be helpful. I said, "What exactly? Help you, and I will get it for you." And they just said, very rote, "We want all of the information from DCJS form, whatever it was, box 27 to 38." I said, "I don't know what that is," and they basically accused me of a liar. I called you. You said, "Oh, that's the domestic violence report form," and I said, "We don't use that." And you told me you don't have to comply with their FOIL request.
The point is,
because you told me I didn't have to create
the point is
a
that
record.
FOIL pertains to existing records.
Right.
It doesn't require that a government agency prepare something new in response to a request. And there's a corollary point too. And I have to say this to reporters and others all the time. People ask questions. FOIL does not require that government agency staff answer questions. We do it all the time. But that is separate from any responsibility imposed by FOIL. FOIL deals with existing records.
And for that, I thank you.
You are most welcome. Good memory, I forgot. Yeah.
Credit card
What about it?
statements. I was denied access because they said they would have to produce a new record to redact the information.
No. There's lots of case law dealing with that situation.
There is.
When they redact, what they are doing is withholding a portion of an existing record. They're not creating anything new.
So credit card records,
Any record, there are a zillion records that include, who knows what, your social security number, the credit card account number. You don't want to give that out either. So you redact. That's not creating a new record.
I actually had a FOIL where they.
That's not creating a new record. That is disclosing a portion of an existing record. And that's their obligation.
I had an agency redact certain words but leave people's social security numbers.
That's called dumb. That's not You know, and as a matter of fact, the social security number is one of the few items maintained by a municipality, other than county clerk, where the government agency has to withhold the social security number. Why? It's the link to everything, right? It's the link to everything.
A person made a FOIL request, and the answer,
Are you from southern Madison County?
no, Long Island.
Long Island, where?
Pick a spot, I've been there.
Where in Long Island?
Mattatuck,
Suffolk County, okay.
and also Belmore.
Belmore, what
Nassau.
street? Oh,
That's
Nassau.
Nassau.
What street in Belmore?
What was that? Broad Street.
Broad Street. You
Same.
too? Where?
We're
Belmore,
husband and wife.
Belmore? So what, Mepham High School or Calhoun or Kennedy or what?
No.
Oh, no, okay, just
She's a Comac girl.
I live, Comac. My son-in-law's from Comac. You know, I'll tell, anybody else from Long Island?
Oh.
It is the land of hostility. It is. Half Boston, half Long Island. You know what I tell people about Long Island? It is a good place to be from. It is. It really is. I went to East Meadow High School, grew up on Belmore Avenue, part of my growing up time. Yeah.
Yeah.
Right off of Belmore Avenue. See, the world is very small. Yeah, you know, and Suffolk County. It's the place where people would rather sue than talk for 5 minutes. I'm not kidding.
They sue over sandwiches.
They sue over everything, and they are nasty. You talk about Comac, there's a school board member there who is being beaten up mercilessly by the superintendent of schools and the other school board members and the school district attorney, and I have a real problem with school district attorney. Any school district attorneys here? No? Do you think they make any money? They make ridiculous amounts of money. And too often, at least in my opinion, they give their clients the answers they believe their clients want to hear. Sometimes they're right, sometimes they're not. It drives me goddamn crazy. Forgive me for my language, but again, as I said earlier, you reach retirement age, you can say whatever the hell you want. Yeah, it's true. Yeah.
Well, my question is, I was used as my name was put in the FOIL as an answer. What
does that mean?
No, I asked a certain question of something and
Which they didn't have to answer.
they
could.
appealed it. Well, no, I asked for record. I asked for an email. They brought me to the point where they said the email I was looking for contained information about him, so they couldn't give it to me.
Well, let's talk a little bit about that. And I have no idea what it's about. But, and I alluded to the exception earlier. One of the key provisions in FOIL, it's actually my favorite exception, says the government can withhold insofar as disclosure would result in an unwarranted invasion of personal privacy. I always ask the crowd, no matter what the crowd is, unwarranted invasion of personal privacy. Anybody know what that means? Nobody knows what it means. Right. Nobody will ever know what it means. There isn't a judge alive who's in a better position than the average reasonable person to make judgments about privacy. And as a society, our views about privacy are constantly changing. I offer an example these days that has nothing to do with FOIL per se. Anybody here ever see what are they, Victoria's Secret ads on TV? Yeah, you record them? Would those ads have run on network TV 25 years ago?
Oh, no way.
Oh no, but why are they running today? Because the sensibilities of society regarding what is intimate, what is highly personal, what is risque, has changed. Now we see those ads, on the Disney Channel at 8 o'clock at night. The world has indeed changed. Anybody here have, what are they called again? Kids? Yeah. Our kids on social media share information with their peers about themselves that you, the parents, we, the parents, would never share. They have a different idea about what privacy is than their parents. How about this? This is my favorite. Two equally reasonable people can look at the same items and disagree. I'll use my own life as an example. We used to have a joke in the house. If the phone rang after 9 o'clock, it was either my mother-in-law or a reporter who'd gotten kicked out of a meeting. They call me mostly at work, but sometimes at night, on the weekend, at home. Doesn't bother me particularly, that's the deal. My name, my home address, my home phone number are in the phone book. Anybody can get them. They're online, in the white pages, anybody can get them. My wife, on the other hand, uses a different name. She'd never put that name in the phone book with a home address and home phone number. Why? 2 reasons. First is painfully obvious. She doesn't want to be associated with me. It's not that funny. Gee, cruel. Second, she's a psychotherapist. She doesn't want her clients calling her at home on her home phone number, knowing where she lives, knowing that she's married to me, knowing that at certain times of our lives, it seems that we just have had too many kids. She has perfectly good and valid reasons for saying no, never. I have equally valid reasons for saying I don't care. And never the twain shall meet. So what do we do about privacy? What do we do? Well, the courts have gone off pretty much in 2 branches. One deals with records identifiable to ordinary people. And the Court of Appeals has pretty much said, react from the gut. What would the reasonable person of ordinary sensibilities feel about disclosure of this item? If it's one of those things where the average reasonable person would say, wait a minute, this is nobody's business, this is intimate, it's highly personal, it's medical information, it's mental health, it's personal financial information, it's something like that, chances are pretty good that the government agency either may or in some cases must say no. The other branch of case law deals with people like me. How many of you are public officers or employees? Few. You know what the courts have said about our privacy? We have less than anybody else. Why? We're supposed to be more accountable than anybody else, right? The public is stuck with us till the next election, till budget cuts, till my case, till retirement or death, whichever comes first. Been eligible for both for a long time. And secondly, the courts have looked at items about us and said in so many instances, those items that relate to our duties in some way usually are public. Why? Because disclosure in those circumstances would result in a permissible, not an unwarranted invasion of personal privacy. You're a teacher, huh? Public school? Was? Public school? Anybody can find out the salary of any public employee, from the dog catcher to the governor. Anybody can find out pension payments. Huh? I can find out yours, you can find out mine. I did retire. I retired and came back 2 days later. People use words like idiot, jacket, never mind. But anyway, and I did that for a reason, which we don't have to get into. But you want to find out when a public employee comes to work or not, it's public. You want to find out whether the teacher or me or the secretary or the dog catcher has been disciplined. If there's a record that indicates that to be so, that is public as well. It bears upon how well or poorly so-and-so has done his or her job. It's public. It's public. So there are lots of things that we can find out about public employees. You mentioned the credit card thing before. Whose credit card are you talking about?
It's a credit card our town supervisor uses.
Okay, is it a town credit card?
Yes. If they pay it every month.
They pay it every month. The only
Different
thing, in my
high
opinion,
amounts.
the only thing that would not be available would be the credit card account number.
Correct.
Why? Because you could use it in, who
But
knows
they
what, buy
said
all
to
kinds of
produce
stuff.
that record was.
I heard what you
right.
said, and they'd
That's
be,
wrong.
what's the word I'm looking for? Wrong, that's the word. That is the word, yes, yeah.
I have a good question.
You say so.
Yeah, conflict of interest.
Not my area, but what's the question?
how can a county attorney be also the, no, well, he's also a town attorney
The appeal attorney
and appeal attorney? How can
for the
they?
FOIL.
Not unusual.
No.
It's
Not unusual, no. I mean, you know, under FOIL, the governing body chooses the appeals person, and it could be the county attorney. It's not at all unusual. Not at all unusual. Why is that a conflict of interest?
Well, that's,
He or she is representing the county. The county is his client, or her client, as the case may be.
It
so,
only becomes if a town and the county have the files.
What are we talking about?
He's concerned that the attorney for his town is also our county attorney.
Really?
yeah,
Well, you know,
It's- and
you
he's
have
most
a,
of the
you have a board of supervisors?
Yes,
Oh, so that means the town supervisors are also on the county legislature.
yes.
Is that a conflict of interest? No, that's just the way the government is set up in that circumstance.
but if
Is
you
that
want
good?
something appealed
Yeah?
and it's against him,
What do you mean against him?
okay. I'll come back with a
Okay,
really,
you think about it. Yeah,
I'm a town supervisor. On occasion, we have what I would call an emergency or a special meeting. What we do is we notify the radio station, we put it on our website, we post it in the conspicuous location in the town hall,
you've read the law.
and we contact board members
Uh-huh.
by telephone, email. What happens if a board member doesn't respond and then later claims that you never let me know that we were having a special meeting?
You make sure that you have a record which indicates that you contacted that person.
What town do you?
Kind of go for, it's never happened.
We should move.
We try to operate above board as much as possible, but the circumstances can be, you know, we usually email, ICC the town clerk, the email, telephone call, the town clerk listens.
Maybe you know section 62 of the town law. Yeah, you do? You do too? How do you know?
Because I've been out this long.
You've been at this a long time. That's the only place in law that I know of that refers specifically to a special meeting. A town board can conduct a special meeting. In terms of the open meetings law, you know, generally speaking, you have regularly scheduled meetings and other than regularly scheduled meetings. You look at the notice requirements, and if a meeting is scheduled at least a week in advance, the law simply says that notice of the time and place must be given not less than 72 hours prior to the meeting. If a meeting is scheduled less than a week in advance, the law says that notice must be given to the extent practicable at a reasonable time prior to the meeting. For what it's worth, I hope everybody knows that the notice requirement imposed by the open meetings law involves only time and place. It is not atypical to disclose an agenda, but the open meetings law doesn't say a word about agendas. You want to have one? Great. You want to have one and stick to it scrupulously? Even better. You want to have one and ignore it? That's your call. You want to not have one at all? Again, that's your choice. That's your choice. In terms of the special meeting, section 62 of the town law refers to the ability of the supervisor to call a meeting 2 days in advance, and the notice, according to the law, must be given in writing. Again, in writing, notice, in order to have a valid quorum, and most people don't know this, in the provision dealing with quorum requirements, one of the ingredients is reasonable notice to all of the members. Think about it. What if the who knows what, the majority in the House of Representatives said, let's get together, not tell the minority and pass bills? That wouldn't fly, would it? It's the same thing at the town level, the county level, whatever it may be. Reasonable notice must be given to all the members. And the notice, as you described it, would be perfectly valid. The notice requirement under the open meetings law these days is generally threefold. Number one, notice must be given to the news media. I emphasize the word given. Why? You might give notice to whatever it may be, the Norwich Evening Sun, or the, is that what it's called? It is.
Nailed it.
Or the Oneonta Star, and they say to themselves, this is not so important that we can take up space. Doesn't matter. You gave notice. That means you complied with that aspect of the open meetings law. Second, notice must always be posted in one or more designated conspicuous public locations. So you don't choose a different telephone pole each time, same one. And third, notice, when you have the ability to do so, should be posted on your website. Whether anybody decides to come, that's up to them. And in fact, I've said this too many times, the open meetings law gives the public the right to attend, but it doesn't say the public has to attend. And realistically, the public stays away in droves. Yes, sir.
If a town supervisor, the town justice, and the town clerk meet to discuss a procedure or a policy that they want to discuss, does that constitute a?
Nope, no quorum of a particular public body, they can do what they want. They can say what they want, they can converse to the extent that they want. The open meetings law simply would not apply. They'd have no authority to take final and binding action. Yeah.
Another example, we have an economic development committee at our town. I'm the only board member that sits on the committee. What happens, you know, they're public, you know, open to the public. What happens if other board members just show up?
If they show up and are sitting in the audience with members of the public and you don't have a majority that functions as a body, to my mind, their presence doesn't change anything. The open meetings law would not apply. Wow. Yeah. You're the hostess.
Yeah, well, I got a question.
I forgot, I had my pills in my pocket, I forgot to take them. That's what happens in old age. You know what happened recently? I became diabetic. Huh. Not a big deal. It's really not a big deal. At least I hope it's not a big deal. Yeah, it's this growing old thing, you know, sucks.
It's wonderful.
Diabetic, kidney stones, any of these. You know, and I have this adorable 6-year-old granddaughter, and she says to me, "Bobby, I'll race you to the next tree." Achilles tendon, you know. That's just the way it is. That's just the way it is.
But you're still alive.
But I'm still alive, and you know, I refer to what I've come to call the James Brown. I feel good. I do. I feel good, and you know, I'm lucky. You know, and I said to the doctor, "What can I do about this?" And he said, "You eat well and you exercise and you're not overweight." I think it counts. You know, it's metformin for those of you who don't know. Yes, half the world I think takes metformin now. Anyway, somebody had a question. Yes, I'm sorry. Our hostess with the mostest. Yes, I'm sorry.
Okay, you have the town board is 5 people, so 3 is a quorum.
Yes.
And they have committees that deal with different subjects.
Who are the members of the committees?
Town board members.
Okay, if a committee consists of 2 or more members of the governing body, it is also a public body covered by the open meetings law. It would have the same obligations in terms of openness, in terms of notice, and the same capacity to conduct an executive session as the governing body itself.
You said 2 or more?
2, the law says 2 or more. I think it's dumb, but I didn't write that aspect of the law. I only wrote, you know, the Great Council.
Question again regarding FOIL. If a person makes a request for her child's records from the public entity.
A child's records?
Her own child.
Okay.
And the entity over-discloses, meaning gives not only her child's records, but the records of hundreds of other students.
What's the nature of the information?
Child with a disability requesting records. So she gets.
That's called a violation of federal law.
Okay, so what obligation does the person who receives the over-disclosure have with?
Let me make 2 points. First of all, since we're talking about records identifiable to students, there is a federal law called the Family Educational Rights and Privacy Act. The abbreviation is FERPA. Most people refer to it as FERPA. FERPA applies to every educational agency or institution in this country that participates in any sort of federal funding or loan program. So it covers every public school district, every public college and university, lots of private colleges and universities too. In a nutshell, it gives the parents of students under the age of 18 rights of access to the records about their kids. Concurrently, nobody else can see those records unless a parent consents to disclosure. So in the context of the situation that you described, the school district presumably gave out personally identifiable information concerning any number of kids in contravention of that federal act. When the students reach the age of 18, the age of majority, they acquire the rights of the parents. Do you have kids in college?
No.
Not anymore?
Never did.
Never did. Anybody have kids in college? I needed my son's consent to get his grades. Why? He acquired my rights, and I said, "You better damn well give me consent." Yeah, yeah. So that's part one. Part two. Where were we going with this?
What obligation does the parent?
Oh, I know what I was going to say. Young reporter, several years ago, called me, and she said, you know, I went to the county clerk's office, I asked for such and such, they gave it to me, and by mistake, they also gave me the records involving the divorce proceeding of a state senator. They were the detailed records of the divorce proceeding. Now, those records, by statute, are confidential, can't be disclosed. And she asked me, what can I do with them? And I asked her, did you steal them? She said, no. Did you acquire them illegally? She said, no. I said, you can do whatever the hell you want. That is the essence of the First Amendment. You find records on the ground and they're confidential by statute, you can do with them as you see fit. What you choose to do is a matter of editorial judgment. She called the state senator. She said, I have these records, do you care? And he said, no. And even though a portion of the record said he pulled a gun on his wife, and you know what? He was reelected. He was reelected. We have lots of dumb people in this country.
Oh, yeah.
Oh, yeah. Oh, yeah. Spoken like a true Long Islander. Oh, yeah. Oh, yeah. Yes.
I heard you say something about, you know, you can't get your kids' grades. Now, back
unless your kid consents, if that kid is
well,
reached the age of majority.
I went to college back in the dark ages. My parents got my grades. I would have just assumed they didn't, but they got them whether I wanted them to or not. So when
that, they were
this
posted
changed?
On the wall, weren't they? When I was in college, they were just posted outside of the classroom.
These got mailed to me and my parents.
Okay.
Now, when did that change?
1974.
Okay. Well, that's way past my time.
Yeah, you know, it's past mine too, so we're in the same...
Yeah, you're a lot younger than I am.
Maybe not.
I'm almost 83.
You look great, you're good
I
and
do.
great, you're fantastic, you're terrific. You remember what Rod Stewart said? You wear it well, you do. You do. I have entered my 8th decade. Don't be misled, that means the 70s.
Yeah.
Yeah. Yes, sir.
I have a situation where I had Code 95 insurance law says anybody withholding documentation and coercing an insurance claim is a felony. And I had FOIL turned in and had the only person that actually gave me the information was the opposing lawyer in court, which when I tried to appeal it and bring this all back, nobody would adhere to the law. So I ended up getting the information myself. And again, it proved the violation of law in felonies of perjury and withholding documentation and coercing an insurance claim, and no one will enforce the law. And I have no record, I have no ability, I've checked multiple lawyers and everything else, DAs, FBI. I spent 10 years on the radio, spent $107,000 out of my own pocket to try to fight it and go nowhere.
I don't know how to answer that question, other than to refer to the Rolling Stones principle. You know that one? You can't always get what you want. You can't always get what you want. And you're right, the system often breaks down. It seems to me if there is clear proof that a felony was committed in your county, the DA should have gone after whomever. It was a federal crime, yeah, the U.S. Attorney should have done the same. But can you compel them to do that? Not usually. Not usually. Sorry about that. More questions? More questions about FOIL or the open meetings law? Come on, yes.
You kind of answered my question regarding privacy.
Yes.
Privacy seems to cover just about anything anyone wants it to cover.
It's not really true.
So that if anyone had a question and tried to FOIL something and couldn't get it,
yes,
the best thing to do is call you, I guess.
I think that that's true. What do you want to get?
It's going to save me a lot of time to call you.
Look, you know, seriously, I've been living with this for an awfully long time. And one of the realities is that, I mentioned this earlier, we have too many laws in this state. Now, for what it's worth, FOIL says that the home address of either a present or former public employee does not have to be disclosed. It doesn't have to be disclosed, but if I own a house, anybody can go to the assessment roll and get my name, my home address, the assessed value of the property. There's a lot of information that's acquired via a different statute. How many of you are familiar with the SAFE Act? You know the SAFE Act? You know, there was lots of controversy associated with gun licenses. And soon after the tragedy in Newtown, Connecticut, the Journal News, a paper in Westchester, Rockland, and Putnam, acquired the list of gun licensees from Westchester and Rockland counties and posted them online. In an interactive way, so that you could look at a map and see if your neighbor has a gun license. Well, you know what people did? They went bananas. And I got, within the space of a week, about 50 calls from all over the country, all over the world. I did my first interview with the BBC at midnight in my kitchen via Skype. I did Fox TV, I did Good Morning America, I did, you know. And the answer at the time was clearly, yes, it's public. The names and the addresses of the licensees for years and years and years had been public. And once you get records under FOIL, you may do with them as you see fit. You want to publish them, fine. You want to use them as wallpaper, that's your choice. Second week, those in Putnam County who don't believe in compliance with law said, we don't care what the law says, we're not disclosing. 50 more calls, can they do that? And I had to say, not if they're going to comply with law. Third week, what about this new SAFE Act? The SAFE Act, as you may know, gives licensees and those who apply for licensees an option. They can opt out of disclosure of their names and addresses. If you don't opt out, your name and address remain public, but if you do, the public has no right to see them. People have come to me and they've said, I feel so much safer now, my name and address are confidential. And I always ask the same question. You a good citizen? Yeah, of course. You registered to vote? Yeah, sure. Anybody can go to the County Board of Elections and get your name and address, and usually your date of birth. Even though the public health law says that the date of birth, the birth record is confidential under the public health law, but you know, go to the Board of Elections. It's a treasure trove of information. So we have a variety of laws and they are not at all consistent. So if you can't get it one way, you get it the other way. Remember what Muhammad Ali said? If the left don't get you, the right one will. Yeah. Yes.
Under the open meeting law, when there is an elevator for disabled, should that be open for an open meeting?
Of course.
So
of
if
course,
it's...
the law has said for years that public bodies are, I don't want to say required, but they are supposed to make efforts to conduct meetings in facilities that permit barrier-free access to physically handicapped persons. Now, that does not mean that they have to construct a new facility,
No.
but if the town hall has its meeting room on the second floor, the only way to get there is the stairway, but the school down the street is flat. Anybody can wheel in or walk in or whatever. They should move their meetings to that second location.
Should or must?
In my opinion, to comply with law, court would say yes, must. Because we have to do what's reasonable to comply with law. Would it be reasonable to say, we don't want to go a block down the street, this is more convenient for us, the town board members, and we can all climb the stairs. Too bad for you. Too bad for you.
You know, what happens, we had an issue with one of our water systems filter plants and called a special board meeting, we publicized it. It really did not accommodate many additional people from the public. Nobody showed up, so it was an issue, but what if several people showed up, they wanted to get inside the water plant for safety reasons? We probably did not want them there.
Again, the law says that reasonable efforts must be made to accommodate the public. Now, if you have an idea in advance that more people are likely to show up than your usual meeting location would accommodate, and there's an alternative location that would accommodate them, it would only be reasonable to move to that second location.
Right. We did the inspection and then we carried our meeting back at the town hall and that was communicated.
So that's fine. And in fact, you know, you're referring to what has become known as the site visit. The site visit, and there's case law which indicates that if the site visit is held for the purpose of observation, and the deliberations concerning what is observed occur after the fact, within the confines of the open meetings law, you'd be complying with law.
Okay. Say that again.
There are cases dealing with a site visit. A site visit, I'll give you the history. The first case, and you'd never know what it was about if you didn't know the facts. The members of this Public Service Commission wanted to tour the route of a proposed power line in a van. Well, gee, not everybody who wanted to go would fit. And they said in advance, they said, we will observe any discussions that we have concerning our observations will occur after the tour at a meeting held in accordance with the open meetings law. And the appellate division in the sentence said, yes, that's okay. And that's where we are. There is now case law that has been more specific and described the site visit. The court reached that conclusion based upon opinions that we had written, based in turn upon that appellate division decision. You want to find out more, you go to our advisory opinion listing, click onto S, scroll down to site visit, and you'll find the opinions. You want to see the opinions that refer to the case called Riverkeeper. Yes. More questions? Yeah.
Do the FOIL laws apply to the Moreland Commission records?
No. Strangely, there's a section of the executive law that says that the Moreland Commission records are confidential unless the governor or the attorney general decide to disclose. It's one of those, it goes way, way back to I think the first decade of the 20th century. So it's been on the books for a long time. But, you know, again, it's one of those statutes that probably shouldn't exist anymore, at least in my opinion. You know, we think of the Tracy Chapman principle of law. Do you know that one? Tracy Chapman? Come on. Best song of the 90s. Baby, just give me one reason, and I'll turn right back around. Yeah. But inherent in that is that it must be a good reason. It must be a good reason.
You've proven your age.
Some people say that's from the 90s, I said. I didn't say the 60s. I didn't say the 60s. Huh. Yeah, I saw Billy Joel when he was 17 with The Vagrants. Remember that?
Oh, man.
Oh, and my grandmother went to Leonard Bernstein's bar mitzvah. So, yes.
Record
Joanne.
management officer.
Yes, it's the town clerk or the village clerk, as the case may be, by statute.
Do they have access to records for the fire district if the town has the fire district under their tax levy?
In my opinion, the answer is no. The fire district is a separate public corporation.
So you would FOIL them rather than an RMO?
Yeah, for that matter, the volunteer fire company is usually a not-for-profit corporation, and more often than not, not-for-profits are not subject to FOIL. But we have a unanimous Court of Appeals decision from 1980, which indicates that a volunteer fire company, number one, performs what has been deemed an essential governmental function, and number two, it would not exist but for its contractual relationship with the municipality. Therefore, it is an agency that is required to comply with FOIL. I could be making this stuff up, but I'm not.
Makes sense.
She's got you on tape. Right over there.
I don't care. You know, I'm from the committee on open government, not closed government. Yeah. More questions? Come on. More questions? Yes.
Open meeting.
Yes.
When they're handing out paperwork to the board and they don't hand it out to the public or to the employees.
You're referring to a situation that led to dozens and dozens of calls, comments, complaints made to our office over the course of decades. We go to the meetings, and the board's sitting up there, and we're in the second row, and they're in the front, you know, looking at page 2, fourth paragraph, and we have no idea what they're talking about. We offered legislative recommendations year after year after year. Nothing happened until all of a sudden, 2011, a bill passed. And it became part of the law symbolically on Groundhog Day 2012. It deals with records scheduled to be discussed during an open meeting. If a record is scheduled to be discussed during an open meeting, and if it is either available under FOIL or if it consists of a proposed resolution, policy, local law, regulation, something like that, it is supposed to be made available in advance online and or in response to a FOIL request. Yes?
How could go on the list, you know, A through Z, a list, where would that be on the?
You go to our website and you go to the right corner, it says News. You click onto News and you'll see a chronological series of entries that deal with developments over the course of time. You scroll down to February 2012. and you will see one entry that is rather general. The other is a lengthy Q&A. A lengthy Q&A, that's where you have all the answers that you need relative to that provision. There was another hand, yes.
Me?
Yeah, you.
I was just gonna ask about minutes.
What about minutes?
Well, because the minutes don't get approved till the next meeting, but they're supposed to be available before that. Okay, that's why I was gonna say minutes.
Myth. How many of you are associated with boards that approve their minutes? Everybody approves minutes. There's no law that says minutes have to be approved. There is no law that says that. It's silly. Excuse me?
Why do they do it then?
Damned if I know. Damned if I know. You want to make sure that they are indeed accurate, I suppose. But let us say that it's the practice to approve the minutes. We look at the open meetings law, and it says that minutes must be prepared and made available within 2 weeks. 2 weeks, 2 weeks, 2 weeks.
Yeah.
2.
Oh,
What'd you think?
thank you. No, that solves my
Except
problem.
executive
2
session.
weeks. Shh. 2 weeks. What if it's the practice to approve the minutes and the board hasn't had the opportunity to do that? Simple solution. Whoever prepares the minutes, and in a town or a village it will be the clerk, because it is that person's statutory responsibility to do so. Prepare the minutes, make them available on request within the 2 weeks. If they have not been approved, they can be stamped or marked on approved, draft, preliminary, something like that, so that the recipient has a pretty good idea of what occurred. Concurrently, the world is given notice to the effect that the minutes are subject to change. Now, Joanne mentioned minutes of executive session. If a board is properly involved in an executive session, it may vote during the executive session unless the vote is to appropriate public monies, which would be rare, in which case it would have to return to the open meeting in order to cast its vote. If action is taken during an executive session, minimal minutes have to be prepared and made available within 1 week. Minutes indicating the nature of the action taken, the date, the vote of the members, and they have to be disclosed to the extent required by FOIL. Okay.
Is the clerk required to be in the executive session at all times?
Town or village?
Yeah.
In my opinion, the answer is yes. In my opinion, the answer is yes, and I'll tell you why. Because the town law and the village law specify that the clerk has the duty of preparing the minutes. Now, the only people who have the right to attend an executive session are the members of the board. Well, what if they don't want the clerk to be there? What if they don't want the clerk to be there and they want to take action? The suggestion has been they invite the clerk in when they're about to take action so that he or she can prepare the minutes. Or the board can do what most boards do. Return to the open meeting and cast its vote there.
But doesn't she have to be there when they adjourn the?
When they adjourn the executive session? Why?
Well, she puts it in the minutes that it was adjourned.
You know, there's a lot of silly stuff that we do. What if it's, you know, here it is, it's 8:15, it gets to be 8:30, one of the board members looks at his watch and says, oh gee, you know, the voice is on in 10 minutes, I gotta go home. And all of a sudden, there's no quorum left, meeting's over, even though there's no motion to adjourn. There are a lot of silly things that we do, based upon history, tradition, policy, not necessarily law. Not necessary. Yes?
I want to make sure I'm understanding you correctly on, I'm speaking of the school board now.
School board's different in some respects, yes.
Okay, but am I understanding you correctly to say that, okay, I'm a member of the board, we've gone into closed executive session, we've made a decision, but then we think we've got to come back out and open.
Stop. You'd be right. Because there are interpretations of the education law that go back to the late 1950s, which indicate that a Board of Education ordinarily cannot take action during a closed session. It must return to the open meeting for the purpose of voting. To the best of my knowledge, there are only 2 situations in which a Board of Education can take action in private. One involves the case, I alluded to it before, where the action is likely to identify a student, where federal law would prohibit that kind of disclosure. The other would involve the initiation of a proceeding against a tenured teacher. Why? Because Section 3020A of the education law specifies that the motion, if you will, to initiate charges against a tenured person must occur during an executive session.
During?
An executive session.
Okay.
But those are the only 2 situations. Yeah?
This pertains to agenda. our county board of supervisors doesn't publish its agenda
Don't have
until the day.
They don't have to.
They don't have to publish an agenda.
There's no requirement that there be an agenda.
Ah,
They can publish it if they want, they don't have to. They don't have to. You know, and in other states, there are requirements concerning the preparation of agendas, but if a board really doesn't want you to know what's going on, they'll discuss whatever it is under new business, old business, other business, something like that. There are lots of ways to avoid accountability. That's,
Yeah.
no, that's the reality of it. That
Yeah.
wasn't intended to be funny, it's true. It's true. More questions?
There has been no need to change a law regarding that?
How would you change it? You must have an agenda and it must be completely accurate. And what if something
They're
new comes
working
up and
for
you
the
want to talk
public.
about it? Are you prohibited from discussing that new subject?
They're working for the public. We
Yeah.
pay the taxes.
Yeah, you do. Can I make a suggestion? Do you remember I said earlier that a board has the ability to establish reasonable rules to govern its own proceedings? You get in touch with your board members and you say, we think that there should be an agenda. And we think that if you have an agenda, it should be accurate and you should stick with it. We want you to establish a policy or a rule that says that you're preparing an agenda that is accurate.
Has not worked.
I go back to the Rolling Stones.
Can't
always
get everything
what
you want.
But you know, if you try sometimes, you just find you get what you need. Yeah, yeah, yeah.
Could a petition do it?
A petition? You know, a petition probably could do it, but I don't know enough about that kind of law, municipal law, to give you a good answer. A petition, probably. Yeah.
Budgets?
What about budgets?
Board gives a budget, it's based not right because projections may have stopped in August and they didn't realize that number didn't carry. So like roundabout now, we're moving money like crazy.
What's the question, Joanne?
How accurate does a budget have to be?
I don't know what the answer is. Come on, how
I mean, like
accurate does
if
a
you're
budget have to be?
if you're $20,000 off of something.
Can't answer the question. I can't answer the question. You know, we're supposed to prepare documents that are accurate. But then for the same token, if you request a record under FOIL and it says 2 and 2 equals 5, unless there's an exception to rights of access, they have to disclose it. They have to disclose it. How accurate must the budget be? I have no idea. We fudge all the time, you know that. We do. I don't say I do. I have nothing to do with the budget process. More questions? Come on. Yes.
Going back to student records that contain personal sensitive information, if somebody requests all of those records appropriately redacted, is the school obligated to disclose them?
It depends. You said appropriately redacted. There may be situations in which the redaction of a name or something else will still enable somebody in the school district community to figure out who the kid is. If that's the case, the school district is precluded from disclosing, at least to that extent. What are you thinking about?
Looking for a pattern and a practice of wrongdoing on a, for an IEP. And we've only gotten those records once, but in every other
See, your
case.
difficulty with an IEP is that often it deals with a student who has, let's say, unique characteristics or something like that. Those unique characteristics might enable you to identify the student, even though various identifying details are deleted. In that situation, if the kid could be identified, the school district, in my opinion, to comply with federal law, would have to say no.
What if they redacted those unique characteristics?
So be it. You have nothing left, probably. Yeah.
But are they required to disclose if they?
In my opinion, the answer is yes. They would be required to disclose those portions of the record which would not be likely to identify the kid.
Even if it's just a date?
Even if it's just a date. Even if it's just a date. You might know the age of the kid. You might know when he started school. There are all kinds of possibilities. It's so hard to give an unequivocal response in that kind of situation. More questions? Yeah.
Is a municipality under any obligation to mail minutes to a resident or something? You know, ours are available, you come
If
to the meeting.
so-and-so is willing to pay
electronically.
whatever the fee
Sure,
might be,
sure.
sure, yeah. What if that person is, we talked about the board members in Florida.
Sure.
What if it's a member of the public who's in Florida during the winter, wants to request minutes and have them mailed? So be it. If they're willing to pay.
Oh, sure, but no, it would be the town expense. And then what happens, they want multiple copies. Our policy is we provide one copy.
That's exactly fine. One copy. They wanna make more copies, so be it, let them make more copies. Yeah, anything else?
Yeah, would you go over what category of business can be done in executive session again?
Well, there are 8 grounds for entry into executive session. 4 of them hardly ever happen. The first, matters which would imperil the public safety if disclosed. Hardly ever. The next 2 deal with criminal law enforcement. We generally leave that stuff to the cops. Third, refers to litigations. Litigation, and the courts have said that the intent of the exception is to enable a board to discuss its litigation strategy in private so as not to divulge its strategy to its adversary, who after all may be out in the crowd. The key phrase to remember there is litigation strategy. 5th exception deals with collective bargaining negotiations involving a public employee union. If you don't have a union, that exception will never come up. 6th is the so-called personnel exception that we discussed earlier. 7th says that we can close the doors to discuss the preparation, grading, or administration of examinations. Hardly ever happens. The last one does on occasion. It says that a board can close the doors to discuss the proposed acquisition, sale, or lease of real property, but only when publicity would substantially affect the value of the property. We think about the effects of disclosure. What would happen if we had to discuss this issue in public? Would the town be precluded from making the best deal on behalf of the taxpayer? Okay, those are the 8 grounds.
When you go to litigation,
Yeah?
potential litigation?
No, proposed pending or current litigation. The courts in those cases dealing with litigation strategy have held that the threat, the fear, the possibility of litigation in and of itself is not enough to justify an executive session. If it were, there'd be nothing left of the open meetings law. How many times have you said, you don't do it my way, I'm going to sue you? We hear that all the time. We hear it all the time. So
Okay,
the notion, again, is to enable a board to discuss its litigation strategy in private so that you don't hear what they're saying.
Okay, so then the litigation happens, the matter is closed. Are the records then,
What records?
whatever the lawsuit was?
Whatever, you can
So
go into
say
the
if-
courthouse when the lawsuit's initiated and
Right,
get
so
whatever
then
is
it
filed
becomes, you
there.
would have to go around it the other way if they're.
Go around it?
Right,
That's your treasure trove of information.
right, right.
It's not going around it,
The
it's
other
just
place.
using a resource that is fabulous. The courts are not covered by FOIL, but you should assume that most court records are indeed public under other provisions of law. If it's a justice court, all of you, I'm guessing, are involved with justice courts. Uniform Justice Court Act, Section 2019A, says in a nutshell that justice court records are public unless the records fall within the scope of a specific statutory prohibition. Yes?
Are they allowed to charge for the records, like per page?
Sure. Sure. The court, you mean?
Yeah.
Yeah, you know, the CPLR, Civil Practice Law and Rules, deals with the rates allowed to a county clerk, and usually a court clerk can charge based upon that same kind of provision, and the fee that can be charged by a county clerk for a photocopy, 65 cents. 65 cents with a minimum of $1. They can charge a lot. They can. And often the fees are more for other kinds of services. Under FOIL, if you want a photocopy, the maximum that can be charged for a photocopy up to 9 by 14 inches is 25 cents per photocopy. Okay?
In special, what I'm trying to get at is if a supervisor is in a executive session
Yeah.
and the public is told what it is going to be about.
As they should be.
Right, and then they go into something other.
Stop. That's called drift, and it's human nature. You know, we all start to talk about topic X and we drift into topic Y. The hope that we have suggested is that there should be somebody sufficiently knowledgeable and vigilant to say, wait a minute, we said we were going to discuss topic X behind closed doors, we've drifted into topic Y, let's go back out to the meeting. Sometimes it happens, sometimes it doesn't.
Now
I know on your board it does because of you.
He's awesome.
He's awesome.
You know, sometimes in the resolution, I'll have 3 items.
So be it.
And we identify each of the 3 in the
That's fine.
resolution to discuss this, this, and this.
Yep. That's okay. The law says subject or subjects.
Okay, so they go into this drift. Are the supervisors,
Continental drift, yes.
okay, whatever. No, what I'm getting at is the supervisor bound to not say anything because it's illegal, they went into something illegal?
Which is less ethical. The disclosure of information which should have been discussed in public in the first place, or keeping it quiet. I think that's an easy one. I think it's an easy one. And realistically, here are two young reporters. I tell reporters all the time, you use one of the rules of human nature, and the rule is, there's somebody on practically every board who's willing to spill his or her guts after the fact. And if that were a crime, God knows, there would be a lot of town board members, city council members, et cetera, in jail, but they're not, at least not for that, you know. Yeah, that's what you do, be charming, be charming, yeah. More questions before I leave, yes?
Something happened here in our county that I've been, just popped into my head. A certain political party was meeting, and I'm assuming in public, and another
Why? Why would you assume that it was meeting in public?
Well, I think they were, in a public building.
That doesn't matter.
I wouldn't swear to anything.
Okay.
Another member of that party opened the door to go in and was told he couldn't come in.
Open meetings law doesn't apply to political party meetings. I don't know what kind of a political party meeting it was.
There's nothing illegal about that.
I don't know. You know, it depends on your own party rules, and they can make their own party rules.
Apparently.
The only political party function, to the best of my knowledge, that must be open to the public is, it's found in the election law, it defines the term caucus to mean that rare situation in which the political party chooses the candidate to run in the next election in which all political party members can vote. That's supposed to be open to the public, but I don't know of any other kinds of political party gatherings that are required to be open to the public. Okay? Yeah.
Let's say someone makes a FOIL request that is not responded to appropriately.
Yep.
And somebody wants to exercise their rights under Article 78. Could you just describe?
We just did.
Mark, could you describe the process of filing a claim to get attorney's fees or costs or whatever?
You look at other cases where that has been an issue. You look at the papers that have been filed with the court. That's the best thing to do, at least in my opinion. Or you hire an attorney who's familiar with the Article 78 process. You know, in the scheme of things, Article 78, to my mind, is relatively simple. I don't want to say it's not complex, because life is complex. As my 6-year-old said the other day, the process is arduous. And I said, arduous? Where did you learn that? Such a little character.
6-year-old.
It's arduous. It's arduous.
I love it.
We're sitting at the table. No, she lives across the street from me, outside of home. That's where she learns the good stuff.
Oh my God.
At dinner, she was fooling around. I said, Leah, this is the time to converse. I said, what does converse mean? She said, interact. Interact, you dodo, yes. Bob, shut up and go away. Either that or, better than that, shut up and dance with me.
Yay.
Anybody remember that one? I heard it 9,000 times, not this past summer, but the one before that.
What?
Loved the song. Now it's all Hamilton. Hmm? You know Hamilton, huh? Yeah, you do. Yeah, you both do. You 12 or what? More questions. I will offer you something that you'll never hear from a state employee ever again. Ask me anything. Go ahead. Make my day. Go ahead. Anything. Anybody, anything. Going once, yes. So then I have a question for you. I go back out the street, I turn right on 12 and then right on 23, is that correct?
Yes.
Huh?
Right up,
And
just
turn
go,
right. Turn left here.
turn left right here by the building.
Which is it, left or right?
Go up to the end of this light, take a left.
Okay.
And then right.
Get onto
Go up
what?
to the gas station, so
Go
that's
to
23.
the second light.
Shit, 23, 32, 49. What is this? What is
There
that?
will be a sign for
There-
State Route 23 if you go down this back road. It'll just say 23.
Okay.
It's not more than a mile away.
Second light.
I can see it, huh?
Yes.
Can I see the light?
Yeah.
I see the light. You remember that? I see the party light, yes. All red and, yeah, never mind, yes.
County easements, is there any way to get a FOIL request for county easements?
If there's a record which indicates the location of the easements, sure, you know, of course. Whether they have a list of county easements or something like that, I don't know. And you never ask for a list unless you know that there is one. Because if there is no list, they can say, sorry, we don't maintain such a record, see you later.
Have you ever seen The Good Rats?
The Good Rats?
You're from Long Island.
What are the Good Rats?
There's a big band, Pepe Marcello.
I think that you're much younger than I am, Joanne.
Not that one.
Yeah, I think you're quite a bit younger than I am.
No Good Rats.
No Good Rats for me?
Tasty?
Tasty?
You had
Give me the 60s. All right, if we're done, I thank you all.
Thank
It's
you.
been Where?
Yeah.
Tomorrow, 9 o'clock at the Desmond in Albany for the Association of Town Clerks. Earlier today, Planning Federation at the Sagamore in Lake George. You know, Wednesday morning, CT scan. Kidney stones. I told you way too much, but that's my life. I just hope I don't get an attack on the way home. Who the hell knows? I mean, you don't know.
The one for